Hello everyone, my name is Brar and I'm with Maharawal Studios. Today we'll be discussing an important topic in family law, the importance of mediation and alternative dispute resolution. I have with me Miss Brar and she'll be joining us. She'll be discussing these topics. Miss Brar is the founder lawyer of one of Lower Mainland's leading firms, LAWHUB. She specializes in family law and she's been practicing in British Columbia for nearly 10 years. So let's welcome Miss Brar to the studio and welcome her on the podcast. How are you, Miss Brar?
I'm good, thank you. Thank you for having me today.
It's great. So today we'll be discussing mediation and alternative family dispute resolution. Mm-hmm. What are your thoughts, just as a brief, about this? What are your thoughts about these options and how you would recommend them over court?
Well, that's a fantastic option for all the family law disputes, excluding divorce, because of course for the divorce you have to obtain the divorce orders. But for any other disputes, including any child custody matters, support matters, parenting issues, property division, debt division issues, so any sort of issues everything can be resolved through these alternate dispute resolutions.
Brar, why would you recommend your clients to go to mediation or seek some form of alternate dispute resolution as to going to court?
My opinion is that family law disputes themselves are very stressful. The reason being that here the families themselves have their own spouses involved, their own children involved, their own properties involved in there. So they're very emotional and that's why they're very stressful. Now, mediations or any other alternate dispute resolution measures, they allow the parties to make certain decisions by selecting a neutral party as a mediator who will help them to resolve all these issues outside the court. So that's how they'll be making decisions for themselves, which will formulate into an agreement, or it can also formulate into a consent order later on, rather than leaving the decisions in the hands of third parties who are the judges. And of course, once the judges provide any orders, then the parties do not have any other option but to agree to those orders. And
are there any other forms of alternative dispute resolution that you may recommend or that you may believe is stronger than mediation?
I wouldn't compare mediation with any other alternate dispute resolution, but at the same time, mediation comes with when you hire a neutral party who is the mediator for their services. But when any family law litigation commences, and if there are counsels involved on both the sides, the counsels can start negotiating processes, and then the collaborative processes can be used, for example, four-way meetings, settlement meetings, to help both the parties come to certain sort of settlement options.
Very nice. Ms. Brar, as you have mentioned, mediation is one of the leading strategies of alternative dispute resolution. How does it differ from going to court or the normal litigation as a layman might understand it?
Several benefits going with a mediation rather than going with a litigation, especially the cost benefit, because it's very, I would say, less expensive as compared to the litigation. Also, the resolutions can be obtained quickly through the mediation sessions, while in the litigation process, you have to go through all the processes to obtain the end result.
That's great. So absolutely, I guess mediation can save a lot of time. And then, as you know, family court cases usually involve a lot of ego, stress, emotions, and that usually prolongs the court hearings or the court processes even further. So my question for you is that as an emotional toll on a family going through all this is very, very tough, right? The emotional toll is very high. Sometimes it can even lead to life-altering events. Mm-hmm. Mediation is something in which there is no third party judging, right? It's just a collaborative approach where the two parties come together and they try to seek some sort of resolution. Right. Do you believe that it is more favorable for a client to seek the litigation aspect, to go to court to prove their chances? Or do you believe that mediation is equally as benefit with a third party mediator?
So when they come together on the table with the third party who is the mediator, they can make their own choices their own preferences in how to resolve the issues between them. For example, if there are children involved, they can have their own parenting arrangements. They can alter the parenting arrangements according to their needs, and a mediator is going to facilitate all that process. So, of course, for co-parenting, for division of your assets, to identify whose debts are these, if the parties are able to amicably resolve that on the table with a mediator, that's far better than having it resolved through the litigation.
I agree with that, and I believe that because, you know, in majority of these family matters that you may have seen as well, and as I've heard, is that there are children involved, and children are usually young and they don't understand what's going on. Having mediation not only helps you maintain a relationship with your ex-spouse, as you had just said, but it also, I think, benefits the children. Don't you think so?
Definitely, the money which the parties are going to spend on the litigation and having that stressful environment at home, which is not in the best interest of the children, because there is no other option for the parents. They themselves are stressed out. So avoiding all that stuff would definitely benefit the children, and mediation is going to ease all that process.
Mm-hmm. Going forward, Ms. Brar, I would like to discuss the role of a mediator. As you are a certified mediator, and you have been for a few years now, what basically in a dispute resolution, what is the role of a mediator? I feel like many people know the term mediation, but they actually don't know who the mediator is or what even the mediator does as a person. So if you can please give us a little bit more information as to regards to the roles and the duties of a mediator.
Sure. Mediator, first of all, is no one's lawyer. So neither party's lawyer can be a mediator. And similarly, the mediator cannot provide any legal advice to any of the parties. The role of the mediator is to stay neutral, only to help both the parties into the process, to have a critical thinking, to have a creative solution for a certain issue, and to come up with some sort of settlement options, to have compromises, to walk away from your positions and meet somewhere in the middle for a settlement.
And I guess all that, and the biggest job, keeping everything calm, right? You have to make sure the emotions stay quelled.
Definitely. So for that, if in some of the matters the parties have very contentious issues, in those cases we do shuttle mediation. So shuttle mediation is that the parties, and if they have a counsel, they sit in a separate room, or if it is to virtual mediation, then definitely there are certain rooms provided to them. And that way the mediator goes back and forth with each party instead of having everybody in the same room.
Mm-hmm. Definitely a creative approach. So mediation, as we have covered, is definitely a vital part of the alternative dispute resolution family. I know that there are other members of that family. So what other forms of alternative dispute resolution is available to clients?
Well, the other processes which can be involved early on would be when the parties have their own counsels. The parties and their counsels can make efforts outside the court to come to some settlement negotiations. So one option can be that they can have a four-way meeting. That is also a collaborative process where after the parties have each other identified with each other that there are certain issues involved and which those issues are, then the counsels can help their own clients to engage into discussions to have those issues settled.
I recently had a friend who was facing a family law issue, and he had told me that he faced some arbitration as a form of alternative dispute resolution. So I just wanted to see how mediation differs from arbitration.
Okay, yeah, so there's definitely a difference between mediation and arbitration. Now, as probably everybody knows that the courts are super busy. So when the parties are unable to resolve their issues amicably, out of the court settlement options are not working for them, then definitely they'll have to seek the court processes, and also through the litigation process they'll have to determine or agree on certain trial dates. Now, being the court's too busy, the trial dates may be in few months or maybe after over a year, depends on when the counsels are available and when the courts are available. In that case, arbitration steps in, which is a great resource the parties can avail. Mediation is where the mediator is trying to help negotiate the issues and trying to encourage the parties and facilitate the process to come to some certain resolutions. Now, if nothing is working, then some mediators also are qualified arbitrators. That means they are able to resolve the issues through providing their own judgment. So that way, that judgment provided is just like a judge providing their own decisions, and then that is binding on the parties.
Ms. Brar, you have illustrated a valuable image for our clients and our viewers to understand what mediation, arbitration, and collaborative dispute resolution means. Please let me know and our viewers when they should employ these strategies and when it's most beneficial for them to seek these strategies.
These strategies can be sought early on. If we talk about provincial courts, some of the provincial courts have early resolution registries. That means right from the beginning, you have to go through processes through the family justice counselors in the form of mediations before even you file your applications. If we talk about other issues which are not covered by the provincial courts, for example, the property division or the debt division issues, then definitely mediation can come early on. Other collaborative processes can come early on. Now, sometimes certain disclosures required from both the ends. That means you cannot have these processes involved right early on. And sometimes one of the parties may not be open to have any such negotiations in place. There is a legislation called Notice to Mediate, which can be enforced upon one party by the other party to have a mediation in force. So mediation or any other form of collaborative processes are running all along. All you have to do is avail them. They can be employed at any point of time, right early on, somewhere in the middle, or even right on the first day of trial.
Thank you. Perfect. You've provided valuable points as to why clients should employ alternative dispute resolution. I just want to know if there are any reasons as to why you would not recommend alternative dispute resolution, such as mediation or a collaborative approach. In what scenarios it might not be fruitful or it actually might go against your client?
I would say there are certain concerns when you should not opt for these measures. First of all, and primarily if there is violence involved. If the parties are very far apart, if there is a certain prejudice involved to one of the parties, or if you can say that mediation is not a safe and appropriate way to resolve the issues, then in those cases, the traditional approach, which is through litigation, should be the best, because you would not want that one of the parties, if they are manipulated to that extent, should be pressed into coming on terms through the mediation process. Aspect which I'm thinking of is the non-disclosure. So if one party has been very naive and the other party has been trying to be manipulative and hiding all the facts, then again the court processes are the best to follow.
Definitely. You've had an insightful podcast here with us today, and you've provided extremely valuable input into the different areas of mediation and different areas of alternative dispute resolution. And I just want to ask, what do you think? Do you believe that mediation trumps litigation in the cases that you have dealt with? Do you think it's a more fruitful approach, or do you believe that litigation overall is the best approach?
I would say litigation is the best approach because being a family lawyer for quite a decade now here in British Columbia, I feel like the way the family law legislation has changed, it encourages the litigants to focus more on collaborative approaches. So definitely collaborative approaches take a priority over litigation. It's going to help and benefit both the parties as well as their children if they have any. And it also is very cost effective, it's less stressful, and you can conclude with the settlement of all the issues through a separation agreement or a consent order. The only outstanding order which stays and can be later on dealt with would be divorces if the parties are married, and that can also be dealt with in an uncontested manner.
Great. We know your time is very valuable, and I thank you for coming and helping our viewers, helping myself understand the different benefits and the different limitations to mediation, alternative family dispute resolutions, and giving us an insight to your life as a mediator.
Thank you for listening to me today, and I'm hoping that whatever discussions, the fruitful discussions we had today, will be really beneficial to the viewers.
Thank you. My name is Brar. I'm with Maharawal Studios. Thank you for joining us on our podcast today. Our guest is Miss Brar, a founder lawyer of LAWHUB, one of the leading family law firms in the Lower Mainland. The topic we discussed today is mediation and other forms of alternative dispute resolution in family law. Coming back next week with another topic in family law, the impact of divorce on children and supporting their mental health through these processes. I look forward to seeing you all there. Thank you.